Right, then I think that we are ready to go. Let's resume our work, and let's indeed start with this afternoon session. So since we are running a little bit late, I would just limit myself to a very short introduction. This morning we focused mainly on international law. That was the prism that we used this morning, the prism of international law. We have been to Strasbourg, we have been to The Hague, and now we continue ideally our journey by going to Brussels and to focus on the European Union. And together with these two excellent speakers, professors, we will reflect on how instrumentalization and instrumentalization of migration in particular is dealt with in the European Union. I would just point out that the European Union gets involved in the game somehow as an international organization. Today, this morning, we discussed about states, individuals, of course, even non-state actors. And now we will focus also on the EU, which is involved in the issue of instrumentalization, the definition, the notion of instrumentalization that we find under EU law establishes that instrumentalization implies a threat for a member state or for the union itself, a situation provoking, aiming at destabilizing a state, a member state actually, and or the EU. So the EU itself is somehow threatened and needs to somehow counteract and react to this instrumentalization. So we'll see now what the EU is doing or has been doing about that. We will start the panel with Professor Daniel Thiem, who is full professor of European Public and International Law at the University of Constance. And then we will continue with Professor Federico Casolari, full professor of European Union Law at the University of Bologna. So without further ado, I leave the floor to Professor Thiem, whose presentation is titled Protect Schengen at All Costs. So thank you very much. Dankeschön, Daniel. The floor is yours.
Grazie, Francesco. Thank you for the invitation to a timely conference. My topic is the broader framework, not a specific piece of legislation. This means that I had to find a way to channel the abstract title into a legal argument. I will develop my argument in 4 steps, which focus on the tension between political preferences on the one hand and the asylum acquis on the other hand. That's how I understand the title. Protect Schengen stands for political expediency, whereas at all costs hints at the pressure on protection standards. First, EU migration policy, what's it all about? American constitutional theory recognizes the concept of a constitutional moment. A constitutional moment is a period of interpretative transformation outside the formal amendment process. It seems to me that we might currently be experiencing such a fundamental realignment of the basic structure of European asylum policy, mirroring the previous reconfiguration which took place some 30 or 40 years ago. At the time, international law, asylum law was essentially confined to the Refugee Convention. The wording of the ECHR remains silent on asylum to this date, and the Strasbourg Court has not yet embarked on the dynamic interpretation. So what was the motivation when states started discussing asylum 40 years ago? And this, looking back, will tell you quite a lot about the present, as I will try to show. The original choice for Schengen, my theme, was a political one. It strengthened the single market and epitomized the move towards political union. That's what politicians wanted. Interior ministers were not happy at first. Over the years, however, they understood that European collaboration allowed them to advance their political agenda. In doing so, Schengen was and is much more than the simple projection of previous internal control practices up on the external borders. Schengen was a laboratory to design new instruments. And the motivation, especially of the original Schengen countries, was to enhance migration control. And the classic case is Germany. Germany received no less than 2/3 of all asylum seekers at the time in the 1990s. It strongly supported Europeanization of asylum policy. That is what we are dealing with today, because they thought this helps us to share responsibility and reduce the number of arrivals. The situation of Italy, the country we are in, illustrates what this meant, as the historian Simone Paoli from Pisa has shown in his work, which I recommend. Paoli reminds us that Italy was excluded from the original Schengen cooperation. It was not a Schengen founding member, and it wasn't for a simple reason. France was unhappy with the migration asylum policy, but also with counterterrorism, which we will leave aside. Italy had at the time ratified the Refugee Convention, but it did not have an administrative asylum system. Moreover, it maintained in the 1980s a policy of visa-free entry towards the Maghreb. There is little France could do at the time when Tunisians reached the border with France. Border controls are never effective in Europe, in continental Europe. Migrants will find it comparatively easy to circumvent the French controls. The situation is different, however, if Italy introduces border controls and visa requirements. And that is exactly what happened in the late 1980s. Italy changed its visa policy towards the Maghreb. Tunisians were required to have a visa to enter Italy and hence Europe. And this was done for several reasons, but one of the reasons is Italy wanted to become a Schengen member. Within the Schengen framework, the classic asylum destination countries in the geographic heart of Europe, France, Germany, Belgium, the Netherlands, they developed a set of migration control instruments any new Schengen member had to accept. Schengen advanced internal mobility. That's what it stands for, at least in the German discourse, but it entailed external closure at the same time. It's, of course, a purely historical anecdote, which nonetheless might be quite adequate in Sicily. But it also shows you that the element of self-interest to control and limit migration has been there from the very beginning. It has defined and even motivated the Europeanization of asylum policy. It is enshrined in EU legislation and also in EU primary law. According to Article 79(1) TFEU, the EU aims for enhanced measures to combat illegal immigration. As you will know, this promotion of state interests, which is the historic origin, but also one of the objectives as until today, is complemented by other objectives advancing humanitarian ideas, such as the fair treatment of third country nationals or compliance with the principle of non-refoulement. And if I had more time, I would show why these constitutional prescriptions require political decisions as to how the tension between control imperatives, protect Schengen, and fairness towards third country nationals at all costs shall be accommodated. They are an abstract constitutional skeleton which permit and also require political decisions on what to do, always within the confines of human rights, of course. At a very high level of abstraction, we can conclude that originally in the 1980s and 1990s, it was control imperatives which dominated the political debate. EU asylum policy at the time was about preventing arrivals. things changed around the year 2000 for maybe 10, 15 years. For all 3 generations of EU asylum legislation, the EU institutions have put a much greater emphasis on protection standards. But what we are experiencing today, or have been experiencing since 2015, is maybe that the pendulum swings back towards more control imperatives. This brings me to the second section, Schengen and beyond, how the external is folded inside. Legally speaking, we have to distinguish between the Schengen acquis, the title of my presentation, and other measures building the area of freedom, security, and justice. The rules on asylum jurisdiction in the Dublin Convention or the follow-up document, for instance, they appeared first in the Schengen Agreement, but they're legally separated from the Schengen acquis when the Dublin Convention entered into force. Other asylum measures may be politically connected to Schengen as well, but they do not officially feature under the heading of the Schengen acquis from a legal and institutional perspective. So when I speak about protect Schengen, I do not speak about the Schengen acquis in a more narrow sense, but I speak about this idea of protecting the European construction in a broader political sense, including the common European asylum system. So when we now move to the substance, at a very high level of abstraction, we might say that the last 15 years, I mean, from 2000 to 2015, have been defined by a fairly generous internal protection regime. But at the same time, the EU has complemented this reasonably generous internal legislation with what is usually called externalization, which is cooperation with third states. And the summary you may use to describe this contrast is organized hypocrisy. You uphold the right to asylum, have fairly generous protection standards internally, and at the same time you promote policies which prevent people from coming. And that is what externalization is about. I need not explain to you that member states and EU institutions have invested an increasing amount of political, financial, and operational capital into what critical academics call externalization, and visa requirements. We had the example of Italy and Tunisia earlier. Also carrier sanctions, both two inventions of the Schengen acquis. They feature in the externalization toolbox, as does the highly dynamic collaboration with Tunisia, Libya, Morocco, Mauritania, and so on. If you combine that with the original motivation behind Schengen, you might say that externalization replicates the original idea which Germany had. The German idea was, or the French idea was, let's enlist Italy to improve migration control by externalizing border controls from the continental heart of Europe to the external border of the European Union. In a way, today's externalization does the same, only that it projects even further by enlisting Tunisia, Morocco, Turkey, and others to control migration from the Europeans, for the Europeans. So there has been a policy shift towards externalization, but it's not new as such. In a way, it's a remake of the original idea behind Schengen, which combined internal openness with external closure. As you will know, European human rights law has sanctions and arguably indirectly supported the turn towards organized hypocrisy that is externalization. Why? The notion of jurisdiction in Article 1 ECHR gives states by and large a free hand when they act beyond the EU's external border, meaning that they have a certain motivation to say, okay, let's the Tunisians, let's the Moroccans do that, because if they do it, we don't have all this trouble under human rights law. And this external, and Hirsi Jama judgment, which is often cited, is at least from today's perspective, the exception to the rule that action beyond the EU's territorial borders is not scrutinized from a human rights perspective. The Strasbourg court has reaffirmed that in the past 5 years with regard to humanitarian visas not covered by Article 1, and for cooperation with Morocco and Libya as recently as last July, SS versus Italy, not covered by Article 1 either. Seen from this perspective, our topic, instrumentalization, which I haven't talked about so far, may be described from a purely analytical perspective as a hole in the invisible wall surrounding Europe, which we have built so effectively and with so much political capital investment over the past 20 years or so. Externalization is fruitless if there is a hole in the invisible external wall, because neighboring countries refuse to cooperate, or worse, from a policy perspective, actively employ migration as a means to exert political pressure. So instrumentalization means that the invisible cordon sanitaire which the European states have built breaks down along a specific migratory route, a route which might even be created by Belarus in the first place. This also entails that the usual distinction which we have in Europe between externalized restrictions, not subject to human rights, and internalized generosity plus some restrictions which are subject to human rights is somehow folded together into a conglomerate of factual tension and political stress. The EU asylum policy is not well equipped to deal with. So in a way, instrumentalization, and I mean that from a purely analytical perspective, forces us to confront the element of closure, which we usually externalize from an EU perspective. So instrumentalization may be the moment which brings the simmering tensions about the future of EU asylum policy to boiling point, and that is exactly what the American constitutional concept of constitutional moment is about. It's a period of interpretative transformation outside the amendment process, which potentially reverses or qualifies the previous interpretation of the legal material. And as I said, it seems to me that we might possibly be experiencing such a period in European asylum law at the moment. That is the more conceptual framework. On that basis, two more legal considerations. As you all know, legislation can be more generous than human rights, and pushbacks are an obvious case in point. Even if the Strasbourg court decided to follow the argument of Lithuania, Poland, and others, they would still be illegal under the asylum procedures regulation. Why? Because Article 6 and 9 of the asylum procedures regulations say quite unconditional that you have to admit someone on the territory. And that brings us to Article 72 TFEU. In a learned audience like ours, I don't have to summarize the instrumentalization debate. Indeed, Francesco has done so this morning. And she started with Greece in 2020. Greek at the time hardly had any legal justification for its actions. In a Twitter post, it relied on Article 78.3, but that is a legal basis for EU action, so totally wrong legal justification. There is apparently a commission legal assessment by the legal service, which was kept secret and has been kept secret to the state. In case anyone has it, let me know. So we don't really know what the legal assessment was at the time, even though Ursula von der Leyen praised the Greeks for being the shield of Europe. When it comes to instrumentalization at the EU's external border, we have discussed the factual situation and the human rights perspective this morning. When it now comes to human rights law, to European Union law, Donald Tusk, the Polish Prime Minister, plays a critical role. And it's crucial to understand that his strategy is the opposite of Viktor Orban, the Hungarian Prime Minister. Viktor Orban has for many years employed asylum as an anti-European propaganda tool, thus triggering a firm response by the Commission and the court. against Hungary. Donald Tusk, by contrast, is embracing the EU institutions. There are several discussion papers which call for a change of direction. There are no regular informal breakfast meetings before European Council meetings where ever more member states participate. The former president of the European Council, which Donald Tusk is, he wants to transform European asylum policy from within, rather than using the topic to mobilize against Brussels. And that is what Viktor Orban is doing. And this has seen some success. First, political. We have several European Council conclusions you will be well aware of, which have lent political support to measures countering hybrid threats. Poland has also called for legislative change, but this has mostly been sidelined or remained very half-hearted so far, as we will learn later when we talk about the crisis regulation. Nevertheless, that need not be the end of the story. Legislation can change in the future, and more importantly, and that is what I want to focus on, the Commission has prepared the ground for a legal detour. There is a communication published almost 1 year ago in which the Commission presented a possible legal blueprint of how border closures might possibly be justified. The communication relies heavily on the public policy and internal security exception in Article 72 TFEU, which you may see on the slide, a provision the court has in more than a dozen judgments compared to the well-known justification standards for trade restrictions in the single market, such as Article 36 for the free movement of goods. You might remember that from your single market class. And so it can be used as a justification for not complying with EU law. And this is settled case law. So judges recognize the option in the abstract, and it remains on the table for exceptional scenarios. That is what the court says, even though it has not recognized the justification in a single case so far. The Commission leaves little doubt that it thinks that the condition for exceptional non-compliance under Article 72 are met at the eastern border at the moment, even though the communication refrains from saying so explicitly. But between the lines, the message is clear. If this assessment was correct, Poland and the Baltic states could rely on Article 72 to set aside the obligations in the Asylum Procedures Directive or the future regulation. The statutory obligation to admit anyone to the country who makes an application for asylum would be irrelevant, even though states would, of course, still be bound by human rights law, ECHR, also the Charter. When we apply Article 72, or when we are discussing whether the legal requirements under Article 72 are met, we must distinguish two legal questions. The first question or hurdle concerns the existence of a threat to public policy and internal security, a condition the situation at the eastern border arguably fulfilled. Note also that the definition of instrumentalization in Article 1, paragraph 4 of the crisis regulation takes up the wording of Article 72. That is already a legislative hint that currently the first hurdle of Article 72, the threat to public policy and internal security, is met. I think that is reasonably easy to cross in the instrumentalization context. If that is correct, we have the second hurdle, which then takes center stage: proportionality. An integral part of this second proportionality assessment will always be whether member states can pursue their legitimate public policy objectives through the instruments contained in EU legislation, such as border procedures or security exceptions, because that is what the court says in many judgments. Before you have recourse to Article 72, use the instrument under secondary legislation first. This argument, as I indicated, has mostly failed or always failed so far. Still, I think we shouldn't overinterpret the relevance of these judgments. They mostly concern situations where government had very little factual arguments on their side. They said, okay, we want Article 72, but there was not really a prima facie case that this should be done. We have not seen any truly hard cases in Luxembourg so far. There might be one exception, and that was about internal border controls. With regard to the former maximum period of 6 months, the court held in 2023 that EU institutions had settled countervailing interest in a definite manner, thus making it impossible for Austria, in this case, to rely on Article 72 to extend the maximum period of 6 months, even if there is a threat to public policy. Some claim that the same must be said about the asylum acquis and the crisis regulation. That would mean that all options member states have is to use the crisis regulation, and the crisis regulation blocks recourse to Article 72. This argument is legally sound. One cannot say it's a wrong legal argument, but I still do not think that the issue is settled. Why the opposite position is equally sound. And in the judgment on internal border controls, judges emphasize constitutional arguments which are very specific to the Schengen area, and it is no foregone conclusion that they will do the same with regards to asylum and instrumentalization. It's an argument which can succeed, but which needn't succeed. So the option of justifying non-compliance with EU legislation on the basis of Article 72 remains illegal. Solid shield governments can employ during scenarios of instrumentalization for as long as the issue has not been settled by the court. This brings me to a very last point, Article 18 of the Charter. It is pretty obvious that Article 72 only justifies disrespect for EU legislation. Member states must still respect fundamental rights. The added value of the provision, Article 72, lies in the possibility of setting aside legislation, not an exit from the EU's constitutional framework. In the EU context, this necessary respect for human rights concerns two guarantees. On the one hand, Article 19.1 of the Charter, which reaffirms the prohibition of refoulement and which must be interpreted in accordance with Article 3 of the Charter, of the Convention. That means I can be very short because we discussed Article 3 of the European Convention this morning, and if Strasbourg decided that Article 3 is not violated in scenarios of pushbacks during instrumentalization, this result would be projected on the Charter under Article 52, paragraph 3. Reading the Commission communication published last December, you may realize that the Commission recognizes the mandatory respect for prohibition of refoulement in a footnote, no more, while the substantive text explains over 2 paragraphs that under international law, Article 33.2 of the Refugee Convention, there is an exception in case of security threats. That's also why my question came up earlier, whether that played a role in the hearing. It didn't, but that's at least an argument the Commission put forward. And quite obviously, this communication published in December last year is first political backing for Poland and the Baltic states, but it's also a thinly veiled attempt to influence deliberations within the European Court of Human Rights. And it seems to me, and it's fairly obvious, that this communication is the first expression we have so far that we might indeed be experiencing something like a constitutional moment at this moment in time, because the EU's executive is finally saying we are willing to revisit one of the basic concepts of European asylum law. One final thought that goes reasonably quick. Article 18 of the Charter is a different matter. It lays down, as you will know, a right to asylum. The precise interpretation of this provision is fairly uncertain as a result of deliberate ambiguities during the drafting process. I've myself invested quite some time over the summer interpreting this provision, and an English language article is forthcoming in some months. I still have to finalize writing it, but it will be finalized soon. And for our purposes, one element is relevant. There is little doubt that Article 18, unlike the prohibition of refoulement under Article 19, is subject to the option of interference under Article 52(1) of the Charter. Restrictions are possible and must be justified. So even if you manage to set aside the Asylum Procedures Directive, even if you interpret Article 3 in line with the arguments of Lithuania and Poland, there would be another legal hurdle, and that is to justify interference with Article 18 of the Charter. And this leads me to three very final thoughts about the legal standards for justification. Fairly obvious. First, the interference must be provided by law. So it cannot only be an administrative practice. You need to lay it down in legislation at the EU level, or if the EU legislation is set aside under Article 72, you need national legislation. The Baltic states and Poland have done so. The second step is you need to comply with the principle of proportionality. This would give the court multiple options to accept some pushbacks while prohibiting others, such as and to insist, for instance, on exceptions for vulnerable group. And finally, and that's what I want to conclude with, Article 52 of the Charter requires states to respect the essence of the right to asylum. Unfortunately, the meaning of the essence yardstick is elusive as well. It was first developed, for all I know, in German constitutional law. That's where it comes from. It was then exported to other countries, but quite tellingly, it has no role in German constitutional role until this day, for the very simple reason that German constitutional scholarship and also practice never managed to answer a very basic question. What is the difference between proportionality and essence? And if you read the court judgments from Luxembourg on the essence, it's clear that for them, essence is something else than proportionality. But what exactly the difference is remains fairly uncertain. And instrumentalization might be a perfect test case to show. Is the essence about the option of each individual to have a right to asylum? So must you make the right to asylum available to each person? Or is it somehow a generic guarantee? Is it enough if you make the right to asylum available to some person? That would be the legal pathway yardstick under ND and NT, a sort of equivalent. So is it the essence of the right to asylum for each person that is destroyed, denied at the eastern border? Or is it a more abstract essence that some persons must be allowed to apply for asylum? The Commission communication leaves this question unanswered. It doesn't even raise it in the first place. That is not surprising. However, the whole purpose of the communication is to present for the first time ever a coherent legal argument, which is more or less silent on Article 3, but under EU law, it's in itself a coherent argument, which you may find convincing or not, but the first time ever a coherent argument which has been put forward, how under the current legislative and treaty framework, pushbacks might possibly be justified in response to instrumentalization. And it seems to me, given that I have been given such a general title, this would be new for many of us, because I think no one of us has dealt with asylum before the year 2000, at least I haven't. and I'm probably among the older participants. But if you speak to people of the 70s, 80s, and 90s, they would say, well, that's actually not that new. That's the kind of argument we had at the time. And if you go back and look at the origin of Schengen, and Italy is, I think, a really quite telling example, you will see that actually it's not that new indeed. Thank you.
Thank you very much, Daniel, for this very interesting presentation. I find very, first of all, a little bit of behind the scenes of when and how Schengen was created 40 years ago, exactly this year, and what kind of dynamics that were going on back then somehow maybe relevant today as well. And this search for legal justification within EU law in the treaty, Article 72, Greece tries 78.3 and then 72, looking at other sources, NDNT, the Geneva Convention. So it's really a legal laboratory that is still going on here. I'm sure there will be questions and comments in the debate, but now it's time for the second presentation by Professor Casolari. Federico, thank you for being here with us. I'll give you the floor. The title of Federico's presentation is The EU Reactions, singular, plural, Solidarity, Emergency, and Sanctions.
Thank you very much, Francesco, for giving the floor. I would like also to thank Massimo and Diego and all the other members of the Palermo team for having organized this stimulating conference. Actually, my talk is very complementary to Daniel's one. The idea is to offer you a zoom out, a general reflection around reactions of the European Union when it comes to the instrumentalization of migration flows. And I would like to do it by organizing my talk, let's say, around the three words you can find in the second part of the talk's title, that is solidarity, emergency, and sanctions. Because I think that these three words, and today we have on several occasions stressed the importance of the language. These three words may try to help us in better understanding what it is happening now at the European level, also, of course, when it comes to the legal implications. I would like to start, first of all, by looking at the interaction between solidarity and emergency. These are two vague notions at EU level, or at least they can have different meanings under EU law, starting from solidarity. Solidarity is for sure a EU value, so in a way it's part of the foundations of the European Union, of the very identity of the EU, if we make reference to the formula that has been elaborated by the Court of Justice in 2022. But at the same time, solidarity is an objective of the EU's action, and solidarity has to do with the protection of fundamental rights of individuals. It's the name of a title of a Charter of Fundamental Rights. So it's a concept, it's a multi-faced concept which has to do with different elements which are relevant at the EU level. An emergency. Well, emergency is something that is more and more mentioned in EU jargon. We speak about emergencies, we speak about exceptional occurrences, we speak about crisis. But there is no, let's say, clear legal definition in both EU primary law and EU secondary law about what a an emergency is and what are the consequences of qualifying an event or a series of events as an emergency under EU law. But having said this, even though these are vague notions in a way, it's possible to find a way of, let's say, connecting these two concepts to make an intertwining between solidarity and emergencies. And in particular, I would say this is pretty clear when it comes to the migration domain, because clearly now we are speaking about, let's say, situations where migration flows may represent possibly a threat to the stability of EU countries and of the European Union as a whole. But we already had in 2015 so-called refugee crisis. So a situation, an emergency situation where migration flows were understood as elements of possible instability for the European Union. And well, at that time, a reflection was made also by Luxembourg judges, by the Court of Justice, on the role that solidarity may play in this respect in terms of introducing legal obligations upon the member states to share the burden flowing from these kind of situations, of emergency scenarios. This is pretty clear in a case that was decided in 2020, the infringement procedure against Poland, Hungary, and the Czech Republic concerning the relocation scheme decisions, where clearly, in particular, I would say in the opinion of the Advocate General Sharpston, it is said that solidarity, which is understood by Advocate General Sharpston as a sort of lifeblood of the European project, requires one, I'm quoting, to shoulder collective responsibilities and, yes, burdens to further the common good. So the idea is that it's possible at EU level to envisage solidarity duties upon the member states consisting of sharing of burden when it comes to an emergency scenario. So we could start in a way saying that in migration emergency scenarios, a first possible answer is to identify solidarity duties upon the member states to manage the situation. This at least was, let's say, the argument made in 2020. And of course, this argument had consequences that have been already mentioned by Daniel in his talk, when Daniel referred to the case law related to Article 72 TFU. The most, let's say, logical and direct consequence is to, in a way, identify legal constraints for the possibility of the member states to invoke unilateral derogations to EU law. So if the starting point, so to speak, is to create obligations, creating a mutual membership imposing the duty to share the burden. So it follows, logically speaking, that the unilateralism of the member states should be interpreted in a very strict way. And that's why we have other cases that have been decided by the Court of Justice, where the Court of Justice has tried to identify those legal constraints, starting from, of course, the idea of a restrictive interpretation of the derogations, the need to double check derogations in the line of the principle of proportionality, the need for the states to invoke derogations only provided that other EU law measures or other EU law instruments are insufficient to deal with the situation at stake, the need to prove if detention measures at borders are adopted by the states, that these detention measures are needed in the light of the behavior of individual concerned, and the need, again, for the states to prove that the crimes committed by the individuals have a direct impact on the crisis at stake. So as you can see, all these criteria put together in a way have identified a legal framework surrounding the possibility for the states to unilaterally invoke security derogations. And this is in line with a more general, I would say, case law of the Court of Justice, which has been named by another Advocate General Pikamer in Slovenia versus Croatia, the framing of powers doctrine. So the idea that basically states, member states have still sovereign powers, sovereign prerogatives. Of course, they are still states, but they are member states. And because of this, the prerogatives must be exercised by the states having due regard to EU law, meaning that there is no general reservation that the states may invoke in order to set aside EU law. So if we apply this doctrine in the context we are discussing today, clearly emerges the idea that let's say, security prerogatives of member states should be invoked by the states not as general reservation. And this is perfectly consistent in a way with the case law I have just mentioned. And of course, this is also in a way a safeguard of human rights of migrants. So solidarity in this respect becomes also relevant for protecting the rights of migrants, limiting the possibility for the states to unilaterally derogate from EU law. Again, the Court of Justice, in the light of this, let's say, general framework I have described in 2023, made it clear that massive flows of migrants are not per se sufficient to demonstrate the existence of a threat to national security, meaning that states have to introduce arguments that have to be interpreted in the light of the principle of proportionality. So these are all elements that, in a way, were let's say, informed by the need to promote and to strengthen a mutual solidarity among the member states in an emergency scenario on the one side, and on the other side, to protect and to promote the protection of fundamental rights of migrants. But then, of course, the picture has changed. Due to the constitutional movement, I'm using your words, that occurred basically in 2022 after the Russian invasion of Ukraine. And basically, what has changed is the global narrative of the European Union. There are new keywords that are now, let's say, a sort of mantra, I would say, in the EU political jargon. Strategic autonomy doctrine, for instance, the idea that the EU has to elaborate tools and instruments to make sure that its vital interests and values can be preserved. From what? From hybrid threats. The Union has, this has been already mentioned also this morning, has elaborated a global approach towards hybrid threats. Again, a vague notion, a vague expression, but the EU and the institutions have tried to elaborate lists of possible hybrid threats that can represent, let's say, significant threat for the European Union and for the legal order. And again, this year in September, Ms. Ursula von der Leyen, the President of the European Commission, started her State of the Union speech by saying Europe is in a fight. So as you can see, let's say the narrative today also at the EU level has completely changed. And the idea is that we are in a fight. There is a hybrid war, an hybrid attack. So there is a permanent situation now which represents, I would say, in its essence, a threat to the security of member states and to the security of the European Union. And as Daniel has already mentioned, the 2024 communication on countering hybrid threats from weaponization of migration in this respect is absolutely a clear illustration of the implications deriving from this new narrative. If it is clear that we are in a context of a hybrid warfare environment, and there is a clear threat to the security of member states and the security of the European Union, well, it's no longer necessary to prove that the situation justifies the invocation by the states of Article 72. It's already demonstrated by the narrative that has been elaborated by the institutions. So member states have no longer, let's say, the burden to demonstrate that in practice, there is a situation that may lead to a threat to national security. So this is to say that this situation has led to a shift in the approach, meaning that we have basically shifted from a solidarity, or at least I would say, let's say, a way of considering mass migration flows from also a solidaristic point of view to, let's say, an approach where migration flows are more and more considered from a securitarian point of view, allowing states and institutions of the European Union to derogate from ordinary standards of action. And in this respect, also sanctions may play a role as well, coming to the last word that it's mentioned in the second part of my talk starting. They play, I would say, a double role in this new approach. On the one side, sanctions and the way which the measures, restrictive measures the Union may adopt against individuals who are involved in instrumentalization of migration flows, the way which these restrictive measures realize balancing exercising among fundamental rights of individuals and the need to protect the security of the Union and its member states. Well, this new way of balancing rights versus security may influence also the attitude, the global attitude of the Union and the member states vis-a-vis the protection of fundamental rights of migrants. This is suggested by the 2024 communication I just mentioned, which, as Daniel recognized before, clarifies that, of course, the rights of migrants may be subject to limitations due to the need to intervene to protect the states and the Union from external threats. And in recognizing this, the European Commission mentions the restrictive measures that have been adopted by the European Union to try to limit the activities put in place by Russia, in particular, to create distortions and instability in the member states. And in particular, more precisely, a judgment delivered by the Court of Justice is mentioned in this respect. It's a judgment that the Court of Justice was requested to give in the Russia Television France case, where the Court of Justice elaborated a balancing exercise on the protection of the rights of the targeted subjects and the need to protect the security of member states of the European Union in a very, I would say, debatable way. It's a situation related to the limitation of freedom of expression and the right of information, and basically the court has recognized that due to the situation and to the war propaganda made by Russian broadcasting services, it was possible for the Union to adopt restrictive measures consisting of stopping, basically, the broadcasting services of these companies, of these entities, meaning basically limiting, I would say, also the assets of the right to be informed and of freedom of expression. But these strong limitation, according to the court, was justified in the light of the need to preserve the union of the member states from war propaganda. Well, what it is interesting is the fact that the European Commission, in its 2024 communication, is relying on this case. It was a case related to the protection of rights of the addressees of restrictive measures, to affirm that the rights of migrants, so not the addressees of restrictive measures, but migrants that are the victims of this instrumentalization of the migration flows, may be limited in the same way. So there is a sort of, let's say, distortion in the way in which the European Commission is referring to the balancing exercise that is needed when it comes to protection of fundamental rights of migrants in these crisis scenarios. And this is a consequence, again, of the general narrative that has changed. Of course, sanctions, and I come into the end of my talk, may also represent an instrument. So restrictive measures may be adopted by the institutions to fight against the instrumentalization of migration flows. This has been done in the case of Russia, in the case of Belarus. Still, it's debatable, but this is for international lawyers, probably not for you lawyers, the validity of these kind of sanctions, due to the fact that these are autonomous sanctions, so they are not implementing measures of UN sanctions. So it's debatable whether or not these kind of measures can be adopted to counter, let's say, protect the Union from the instrumentalization of migration flows. Well, let me conclude by coming back to solidarity. So clearly, as you can see, this new constitutional moment is putting under stress the meaning of solidarity under EU law. When it comes to the mutual solidarity among member states, and this is clearly due to the fact that the more we stress the possibility for a single member state to unilaterally invoke derogations, the more we are disrupting the mutual solidarity among the member states, but also when it comes to the solidarity that should be shown towards the migrants, the victims of this instrumentalization. And this clearly emerges from these indications on the balancing exercise that are given by the European Commission in the 2024 communication. Well, of course, it's always possible to hope that the Luxembourg judges will be able to, let's say, find a way and to, in a way, go back to the cases that I mentioned at the beginning of my talk. But let me say that we cannot always ask judges to solve the challenges of our time. It's not the judge's task. And at the same time, we have already seen that also the judges of the Court of Justice in crisis or emergency situations, to borrow from Steve Pearce's words, may read newspapers, meaning that also the Luxembourg judges in this new constitutional momentum could decide to, let's say, adopt a different approach from the approach that was taken in the past. Thank you very much.
Thank you. Thank you very much, Federico, for this very rich and interesting presentation. I'm personally fascinated by how many legal sources emerged during these talks, ranging from judgments of the courts, judgments that we are waiting for, and judgments that we already have, treaties, international treaties, the treaties of the European Union, soft law acts, including this communication by the Commission that is, however, relevant. I think also we mentioned the letter by the 9 member states of the EU and of the Council of Europe. All this shows that something is really brewing, and we are in a constitutional really moment and an atmosphere of change, perhaps decisive change. So I would now I will now open the floor for questions, comments, remarks. Yes, I see. Quite a few hands coming up. So that's good. I would maybe invite you here to pose your question using the microphone, so that also those that are attending online can actually hear the question. Thanks.
Thank you. Thank you so much, both. I have a question for Daniel on what you said about the operation of Article 52 of the Charter on the interpretation of the scope and content of the rights of the Charter in the light of the interpretation of the European Court of Human Rights. And I'm not an expert about EU law, so I'm really curious about this. But you said that if somehow the European Court of Human Rights is going to change its interpretation on Article 3, this would reflect on the interpretation of the prohibition of refoulement in Article 19, paragraph 2. But I have 2 questions. So there are 2 possible scenarios. So let's assume on the one hand, and of course I don't agree, but let's assume on the one hand that states are right and the prohibition of refoulement does not exist in Article 3. It was a interpretative creation of the European Court of Human Rights. Then it means that the only equivalent of Article 3 in the Charter is Article 4 of the Charter, and that then every interpretation of Article 3 by the court does not affect the interpretation of Article 19, paragraph 2, that it's a further right that was recognized in the Charter. So in this case, it would be entirely irrelevant. The other option, so let's assume that, as I think the refoulement is included in Article 3, and that therefore the interpretation of Article 3 also is relevant for the interpretation of Article 19, paragraph 2. But then my question is, would this be automatic? And what is the role of the final sentence of Article 52, paragraph 3, which says this provision shall not prevent union law providing more extensive protection. So should it immediately low down the protection provided by the Article 19, paragraph 2, or is there room for safeguarding more rights in the European Union system? Thank you.
Okay, yeah, maybe I would collect a couple of more questions or comments. Thanks.
So now I really want to hear the response to that question, actually. But I have a very short question that a bit jumps on that as well. So if I understood rightly, then there is a proposal out there to interpret primary EU law in a way that allows pushbacks in certain aspects, kind of that, not all pushbacks, but some pushbacks. And to understand this proposal, I try to understand two things. So firstly, I understand it's proposed in the context of instrumentalization, but as I see EU law, if there's this exception for instrumentalization, it needs to be an exception for everything, right? So I would like to understand how far this exception would go. Because from EU law, I would not see just an exception for security reason or just for instrumentalization reason. So that's the exception is the first question. And the second question is on, it cannot be excluded at all. So someone needs to be allowed, kind of, I understand, but that's the interpretation. So it's like some people would be able to be pushed back and others claims would need to be assessed. So here's the question, would that, is that again coming back to this vulnerability clause that Poland, Lithuania, and Latvia are proposing? So there the proposal is that we can push back everyone who's not pregnant, underage, and so on. Is that the case? Or is the interpretation going in a different direction with regard to this, who cannot be pushed back?
Thank you for both your presentations. I have a question that more relates to what Daniel brought up, but both of you might have something to say about. So I found it very insightful and astute description that instrumentalization is sort of the counterpart to externalization, and that, as you described it, it's the breakdown of the cordon sanitaire at one point, with all the continuity also that you mentioned from, let's say, an inner EU externalization to an outer EU. But then, to me, that has such huge, if we realize that, what would that mean for what legal and political consequences of realizing that it's just the other side of externalization? So to me, it brings back the discussion that we've sort of let's fade it away a bit about responsibility sharing, because I feel realizing that externalization doesn't work, and ultimately that it keeps coming back in the form of instrumentalization or of the instrumentalizability of migration, means that we cannot keep it away. But on the other hand, it can't mean that every state has to deal with all possible asylum claims alone. So I think the actual legal and also political response would have to be agreements about the sharing of responsibility, and that then relating also to the discussion on solidarity. But to me, there was a bit of break then to the Article 72 discussion, because I feel that goes to a level of shifting away individual responsibility of states without trying to tackle the issue at large. So don't we need a renewed debate on responsibility sharing, both intra-EU and internationally, instead of going back to those, let's say, individual tools of shifting responsibility away?
Yeah, well, there is quite a lot on the plate, but I would just add a question from the chat, and then I'll give the floor to the speakers. There is a more, there is a broader question. The question is, in what sense are we experiencing a constitutional moment in the European Union? And why most evidently in the field of asylum and migration? All right. Okay. Daniel, you want to address the questions?
I start first. I start in the order which it was presented. Yeah, no, I was very short on that point. It's a very good point, and you gave me the opportunity to raise these aspects. I mean, you're absolutely right. Article 19.1 of the Charter sanctions stirring. So if stirring was overruled in Strasbourg, stirring would remain in place under the Charter. That, of course, doesn't answer the question, how far does stirring go? So in a way, for EU member states, now from a governmental logic perspective, to overrule stirring might be a Pyrrhus victory, if that term exists in English, because you get rid of Article 3 of the Convention, but you keep Article 19, and if you keep Article 19, you keep it as it probably is right now. So for member states of the European Union, it might actually be better to get an exception from the prohibition of refoulement in Article 3 of the Convention, because if that was the outcome, you could easily project it on Article 19.1 of the Charter, because 52.3 says it has to be interpreted accordingly. That's my spontaneous response. I hadn't thought it through myself until a few moments ago. That brings me, of course, you are absolutely right, and you read it out. Article 52.3 says higher standards is possible. If now I was asked as an EU law professor, but you add your opinion as well. If I was asked that question totally irrespective of instrumentalization, my answer would be that means situation where the Charter establishes a higher level of protection. For instance, with regard to Article 47. Article 47 is broader than Article 6 because it also covers classic public law disputes, police action, and the like is not covered by Article 6, but it's of the Convention, but it's covered by Article 47 of the Charter. So I think that would be a classic case where the higher standard exception applies. Theoretically, you could also apply it to an interpretation of a provision which, as a matter of principle, has the same meaning as the ECHR. Doctrinally, that's possible. I don't think that's the normal situation which the drafters of the Charter had in mind, but that's possible. And in that respect, I mean, over the past 15 years, we had from 2011 to maybe 2017, 18, roughly speaking, we had the debate that Luxembourg was stricter than Strasbourg, especially in Dublin cases. And everyone said, oh, no, we need parallel interpretation. So in a way, this would be now the same argument in the reverse. No, this time you don't follow Strasbourg. This time you follow your own interpretation. And my intuition is that with this half-dependent argument that Luxembourg has to follow Strasbourg, that is very unlikely. I think Strasbourg over the past 5 or 7 years and Luxembourg, they have settled in a situation where they really walk hand in hand. That's my perception, totally irrespective of migration. You might disagree, and you have worked in Strasbourg, but that's at least my perception when I read the literature. And yesterday in the plane, I read an article by Shifra O'Leary, president of the ECHR. Also, when I listen to Lennart's, that's very much the message I take with me. They want to be seen singing from the same hymn script, but I might be wrong. And doctrinally also something else can be defended. Regarding Article 72, I mean, the German, French, Italian version says public policy and internal security. The English says maintenance of law and order and internal security, but that's actually probably not how I also use it in English. I use public policy because that's the other language version. And that also brings us back to this very basic exception clauses, which we learn in internal market law. Article 36, free movement of goods is the paradigm. That indeed theoretically can have a very broad meaning. And that's also the ambiguity of Article 72, that as a matter of principle, it can cover a lot of situations. But that's also why the second hurdle, then proportionality, becomes irrelevant. And the way I presented it today, all under the heading of proportionality, it's much more than the usual weighing exercise. It's essentially this question, do you have utensils, instruments, which you can use in EU legislation to counter the public policy threat, even if it exists, which make it not necessary to set aside EU legislation. And that in the case law is a very, very powerful instrument. But I think Salvatore will speak about that later as well. So I can be very short here. And regarding proportionality, I refer to Salvatore. Regarding this external holding inside, it was a spontaneous idea. I presented it. I don't want to draw any political or normative in the sense of legal consequences from it. And in that respect, and I take that as a sort of criticism, and maybe rightly so, there is a certain break in my presentation. First, it is analytical, more or less conceptual, not theoretical, but it tries to analyze or describe what the European Union is doing. And then it becomes more legal, but I wouldn't draw any immediate consequences from the first analytical part when it comes to the second, except from pointing out that this emphasis on restriction, which is there, is not totally new. It's somehow, it has been an integral part of EU migration law from the beginning. In a way, it has been the starting point of EU migration law, has been restrictions, because that is what the 5 Schengen members wanted. And Schengen is the origin also of Dublin, negotiated in parallel. And then on all of that, the European asylum system was built. So the story we tell nowadays, which often starts with Tampere, is maybe incomplete because it ignores what happens before Tampere. And Tampere is a very specific moment in time. So there is a certain methodological or whatever break in my presentation. Having said that, solidarity, what I find, we all want solidarity, but we mean different things. And that's what I always find fascinating in debates about solidarities, because it tells you quite a lot about the normative starting point. And if you say sharing people or sharing responsibility, that need not mean sharing people. You have a certain vision of asylum policy. Probably Poland and also Ursula von der Leyen would say in the instrumentalization debate is very much about solidarity. Poland would probably perceive the Commission communication as an act of solidarity from the Commission at a level of legal argumentation. They will perceive sanctions against travel companies and the like as an act of solidarity with Poland. So solidarity can also mean we really counter instrumentalization. And the way, if you look at the solidarity mechanism in the pact, one of the instruments is that you can actually support third states, and that's a solidarity measure. And that's probably also how many European states, with Giorgia Meloni, I don't want to be too political, but Giorgia Meloni would say it's an act of solidarity if Mr. Rutte, the former Dutch prime minister, flies with her to Tunisia to negotiate with Mr. Said, the president of Tunisia, that he prevents the boats from leaving Tunisia in the first place. So I think there are many perceptions or conceptions of solidarity which have probably shifted quite a lot since 2015. And probably, and that I realize attending also this conference, instrumentalization is embedded into a shift which we have anyhow, but it's really a prism. And it's not only a prism, it's a catalyst. It really reinforces a trend and which has been happening anyhow. And it's a perfect prism to really analyze that trend which we are having. And if I may ask a question to you, with regard to emergencies, I mean, emergencies, how they have usually functioned in EU law and how they function in the internal market is we have EU law, that's the common interest. And then the member states say, I have a problem, and then there is a vertical exception. But when we discuss instrumentalization, in a way, the emergency is integrated into EU law. So it's EU law which changes, and it's not EU law which stays intact, and then member states get an exception. But in a way, emergencies are internalized, and it's now a horizontal emergency, and it's used to change EU law. But that's only a thought.
Thank you very much. I tried to have some reflections on some of the points touched so far. Well, solidarity. Yes, so as I told you, solidarity has different meanings under EU law, and of course, this also means that has different understandings. We could say that, I mean, I think it's to speak about the objective of solidarity, and we can have a different interpretation. So for sure, it's an act of solidarity in favor of Poland to support Poland to be protected in a way from possible external threats. But when we speak about the legal implications of the notion of solidarity, we have to speak about the duties, the obligations flowing from these notions. So we have to speak about the principle of solidarity. Well, it seems to me, at least, but I know that in the legal literature there is a debate on that it's difficult to find a general principle of solidarity at EU level. It seems that a principle of solidarity may be invoked in emergency scenarios. And in particular, it consists of obligations of sharing burden among the member states, but also among the member states of the European Union. Of course, we have a case of the Court of Justice in the energy sector, the Opal case law, where the court has tried to elaborate a general principle of solidarity starting from the energy policy of the European Union. But if we look at the words of the court, this principle of solidarity basically means that the EU institutions in elaborating pieces of legislation have to take into consideration the interests of the member states. This is clearly something that the EU legislature has to do, I mean, always. In every field. So you don't need to have a principle to say that the EU legislature will consider the position and the interests of the member states. So my position is that we have legal obligations for the states, but also for the Union, coming from solidarity in emergency scenarios. And if you look at let's say the treaties, the solidarity clause, cases concerning the lack of difficulties in having energy supplies, the migration domain, it's normally mentioned in emergency scenarios, meaning that there is a need to share the burden, to have a common responsibility, a mutual responsibility. So this is my understanding from a legal point of view. Then, of course, solidarity, if you wish, is also the de facto solidarity of the Schuman Declaration. But we are not speaking about a legal notion imposing legal duties. And this leads me to the other point concerning sharing responsibility, sharing obligations instead of stressing, let's say, the unilateralism that this kind of recent practice reveals. Well, this is, of course, I completely agree with you. I mean, it would be better to elaborate approaches and legal solutions that are inspired by the idea of sharing responsibilities, by the idea of strengthening the mutual membership of member states, by the idea of strengthening the, let's say, projection of European Union towards multilateralism. But if we look at the context within which we are, well, and the constitutional momentum, it seems that this is not what the Union and the member states are interested in at this time. And to try to connect this reflection to a question that was posed online, I think it's a general constitutional momentum for the Union. So we are now speaking about the instrumentalization of migration flows. But please consider what the Union is doing under the common commercial policy. Consider what the Union is doing in using or abusing the general internal market clause to elaborate unilateral instruments to protect its values and its interests. Look at the way in which the emergency legal basis, Article 122, is used. So clearly there is a general attitude today which is inspired by the idea of elaborating such a strange strategic autonomy. And this general attitude consists of, let's say, trying to make the Union more autonomous. And so, of course, this means that also at EU level, unilateralism seems today to be the most, let's say, relevant recipe for trying to solve challenges, which is absolutely in contradiction with the DNA of the European project. The European project was created to strengthen the multilateralism after the end of the Second World War. So I would say that it's really a general constitutional moment because it has general constitutional implications for you. The blurring of legal basis, the blurring of the allocation of competencies between the Union and the member states, the lowering of the importance of international obligations of the European Union, the rise of informality in the EU lawmaking. So there are legal implications that are undermining the constitutional framework of the European Union. That's why I think we can speak about a constitutional momentum of, if you wish, the constitutionalization of the European Union due to the actual circumstances. And, well, national security, public policy. Well, I agree with you, Daniel. Again, we don't have a clear, let's say, understanding of the outer limits of these notions, also because the institution starting from the Court of Justice use these notions in a very imprecise way. Yeah? We have cases where the Court of Justice makes reference to public security, and then in the following sentence we have a reference to national security. So it's not completely clear for at least for the court, the distinction between these two notions. So it's a very, let's say, broad understanding, identifying situations where states are entitled to rely on their essential interests. So we have to go back to Article 4, paragraph 2 TU, their essential functions, in order to derogate from EU law. So basically, there is an inherent connection between, in this way, Article 72 and TFU and Article 4, paragraph 2 TU, which gives a possibility for the states to basically derogate from EU law as a whole, according to, let's say, the structure of the EU treaties. Then, of course, we have a case of the Court of Justice trying to limiting this possibility, of course. But this is to say that I agree with Daniel. I mean, it's impossible, at least as for now, to identify clear limitations to these notions. And then there is a new notion which is the notion of supranational security, which is something new, which is something related to this new constitutional momentum, gaining more and more space in the EU debate, and complementing in a way the national security of member states. Well, what about emergencies? I think that again we can identify different qualifications and different roles for this concept under EU law. For sure, the notion of emergency is relevant, as you said, Daniel, in a vertical way, giving the states the right actually to derogate from EU law. But emergencies are also relevant in order to trigger some EU law mechanisms. The Union Civil Protection Mechanism, for instance, it's a piece of EU legislation, and it's related to the possibility to give assistance to states, member states, or third countries, victims of emergencies. And we have also, if you look at the health sector, we have another piece of legislation which is applicable in cross-border situations representing a threat to health. So this is to say that actually, yes, emergency can be a notion invoked by the states to derogate from the law, but it's also a notion that can, in a way, make possible to apply some pieces of the law. And then, of course, we have situations where emergency, the notion of emergency is no longer something that it's relevant for a single state or two or more states, but it's something, let's say, horizontal or something inherent in the EU legal order as such. And I think that the most illustrative example we had so far was the COVID-19 pandemic, clearly, where the emergency at stake was, of course, an emergency for the states, but also an emergency for the EU as a whole, a threat to the functioning of the pillars of the integration process, starting from the fundamental freedoms of the EU internal market. And in this case, we have seen that there was the possibility to try to have a coordinate answer, reaction, also via informal or non-binding instruments, to try to elaborate a common approach to prevent the possibility that the unilateral action of a single member state may undermine the pillars of the European Union. Well, we should try to go back to this experience. We should not forget what happened 5 years ago. Trying to, let's say, formalize, codify some of the solutions that were identified at that time. It seems that the approach taken now is completely different. It's more based on unilateral solutions than on the need to try to find and to preserve mutual and cooperative solutions.
Thank you. Thank you very much, Federico. Thank you very much, Daniel, for your efforts to try to address such broad and complicated and constitutional issues indeed. I would then conclude this panel. Thank you very much once again. And let's now prepare the floor for the next and last panel.
It's everything's changing.
I think that we may we are in the process of beginning the last panel, and I have to say that Professor Enza Tramontana, that was supposed to chair this last panel, unfortunately, she has some personal business, so she is not able to be with us. This is why I'm again taking the floor. I hope that you are okay with that. Just a quick check. I don't know if Alexandra Anchite Yepanova is already connected. Yeah, I see her. We cannot hear you, but maybe because your mic is closed right now.
Yeah, so you should be.
Okay,
Yeah,
good.
can you hear me now? Perfect.
Obviously. Just one question, Alexandra. I don't remember, do you have any slides or
Yeah,
material?
I do. I'll try to share.
Okay, maybe it's better. I'm thinking about this right now. Maybe it's better if you share your own slides. Maybe it's better than
Okay,
having
I'll
us to
try
share.
to.
I don't know if you have the privileges, the capability of doing that.
We'll try this way. I'm not quite sure if it works. Just a moment.
Okay, if it's like ours,
Just a moment.
in the upper right corner, there's a logo of a screen with a share, I guess.
Yes, I'm just trying. You know, it takes a little bit of time because it's.
Okay.
You should be able to see it in a
Okay,
minute if
there
it
we go.
works. Yeah, can you see it? Can you see it now?
Yeah,
On the screen,
absolutely.
yeah,
Okay, that's fine.
perfect.
So
Yeah, great.
I think that we can start as we are running a little bit ahead of a schedule. Seems like we are on a high-speed train in Italy, I guess, so 35 minutes late. And but still, we can make it. And this is the third and last panel entitled Responding to Instrumentalization Through EU Law. To a certain extent, some topics or some reflections have already been put on the floor for the discussion in the previous section. So in this panel, we will have a different take on this topic. So our speakers are Alexandra Yepifanova, excuse me. She is connected online, and Salvatore Nicolosi is here right with me. So I think that we can start. So Alexandra, the floor is yours, and I would say 25 minutes, more or less. And yeah, we are all ready to hear from you.
Thank you so much. Thank you so much for your very kind introduction, and hello to everyone. I'm very sorry for not being able to present in Palermo due to some technical issues, so to say, at the airport. Unfortunately, I missed my flight. However, I'll be talking today while approaching the migrant instrumentalization paradigm from a little bit of different perspective. So I am an interdisciplinary scholar, and I have carried out field work in all the 3 member states bordering Belarus. And today, what I'm going to do is, can you hear me well? Because I hear some sort of an echo. Yeah. So what I'm trying to do today, so it will be a little bit non-traditional way of presenting, because I just changed the way I'm going to present in the very last minute. So I will not be talking so much about EU law. I will mention the definition of migrant instrumentalization, which has been incorporated in the newly adopted crisis, force majeure, and instrumentalization regulation. Because the topic of migrant instrumentalization and the definition exactly of migrant instrumentalization has appeared so many times during the previous presentations. And I just had an impression that we really need to focus on the very definition, going back to the very essence of what migrant instrumentalization really is, how it is perceived and how it is defined from a legal perspective. Because here, what we are seeing now is that for the first time, the concept of migrant instrumentalization has moved from the political into legal domain in EU law, and also in the legislation, first domestic legislation of the member states for sure. So I would like you to have a look at the definition of migrant instrumentalization. We can now see in the regulation, which has now been adopted. And I'll go from there. So what I'm trying to do, I'll try to unpack the various elements of migrant instrumentalization as it appears in the definition. Of course, as has been previously mentioned by previous speakers, Grażyna more specifically, that it is very unlikely, basically, that EU member states will ever rely on this regulation, because what we are seeing now is they have gone so much beyond what is already permitted in the regulation by legalizing pushbacks, by severely restricting the right to seek asylum, or suspending it whatsoever, even though they claim not to do so. However, if we look at how migrant instrumentalization has been defined in the regulation, we can see basically 3 or 2 very broad elements of this. So first of all, the situation of instrumentalization occurs where the third country or hostile non-state actor encourages or facilitates the movement of third country nationals to the EU's external borders with the aim of destabilizing the Union or a member state. And also the second element, which is a broad element, where such actions are likely to threaten essential state functions, including the maintenance of public order or the safeguarding of national security. And I would like to go through all these elements with reference to my research I've carried out on the border, and see how these elements actually correspond to the situation which we can now observe at the border with Belarus. So my methodology is mixed. I've done both legal analysis and field work. And by field work, I mean that I carried out a lot of interviews with people who are lawyers, NGOs, who work directly with people who try to cross from Belarus and who try to assist them, provide humanitarian assistance, also legal assistance. And I myself also interviewed more than 50 non-EU nationals directly who attempted to cross into the EU from Belarus over the course of several years. And I've been in touch regularly with people directly who try to cross the border. So these have not been easy interviews on many respects, but I will not be going too much in depth of how I have conducted those interviews. But it really reveals the patterns, the ways how they try to enter the EU and why they have chosen Belarus. And just to give you a little bit of a background, what we're talking about from a very general perspective, the Belarusian route. So what happened before 2021? Because it's normally, it's very typically, I've seen that a lot, that we're talking about something which has been like started like since 2021. However, we should remember that Belarus has long been a transiting route to the EU due to its geographical location. So for people traveling from the Caucasus, from Russia, in particular from Chechen Republic, where we know that about the human rights violations, Central Asian countries, Afghanistan, at certain time periods from Vietnam. And the EU member states bordering Belarus have long carried out pushbacks at that border. And also, like, for example, Poland is infamous for denying entry to people, even those who arrive through official border crossing points. Through Belarus, we have like several judgments of the European Court of Human Rights about that. So this is not a secret, and the numbers have been actually quite significant. Comparing to those numbers who now try to cross from Belarus. So Poland has been like denying entry to thousands of people over the course of years. So we also need to remember that the EU had been paying Belarus before 2021 for protecting its borders through various projects. And in total, it has allocated over 80 million euros to Belarus through different border management projects, which have not been super visible. However, this is the case. In 2021, it changed because after the EU imposed sanctions in Belarus, what Belarus did is suspended the EU-Belarus readmission agreement, which was signed, if I'm not mistaken, 2020. So it was relatively recent. And also, like it was explored before in detail, like a relaxed visa regime for nationals of predominantly Middle Eastern African countries, and also, which is crucial, stop preventing irregular border crossings into the EU. So here we can see two elements. First of all, the relaxation of visa regime and offering packages, just to somehow facilitate the transfer of people to Minsk from their countries of origin, and also stopping preventing irregular border crossings into the EU. If we look at the statistics, why it has been portrayed as a mass influx of migrants in absolute numbers are very low, extremely low. However, comparing to the numbers of asylum seekers in all the 3 member states involved, these have been like significant increase. And this is what triggered these sort of anxieties in these member states, this sudden increase. And also second element, of course, that Belarus, it has been Belarus, a Russian ally, which has also been perceived as particularly as a threat, especially after the Russian invasion of Ukraine has intensified. However, my question now is, we know that, okay, so the instrumentalization period has been there from summer 2021, actually until the end of 2021. I'm talking about the packages which people were using to travel to Minsk and then to the EU onwards with Belarusian visas. So about this particular pattern, we can be talking about the period, which is a very short period, which is from summer 2021 until the end of 2021, because afterwards the pattern has changed. In particular, it has changed after the EU pressure on foreign airline companies, which following that introduced travel restrictions on nationals of certain Middle Eastern countries, which were discriminatory travel restrictions. People with certain nationalities, like for example, Syrian, Yemeni, and Iraqi, could no longer board flights to Minsk. And also hundreds of Iraqi nationals were returned from Minsk to Iraq via so-called repatriation flights. And this has changed the dynamic of what's happening. And this is where things got interesting. Because my general question is, okay, so if we accept that there has been an instrumentalization, when does it end? When is the end of instrumentalization? Does instrumentalization, because at the moment, member states still are talking about migrant instrumentalization without specifying what the instrumentalization means. In particular, people continuing crossing the Belarusian border into the EU automatically, for the member states, it means that instrumentalization is still ongoing. However, if we unpack that, most of third country nationals currently arrive in Belarus from Russia. And first of all, if we are talking about the visas, generally, both Belarusian and Russian visas, because many people do have Russian visas. So first they travel to Russia with Russian visas obtained in their countries of origin or third countries, and then try to cross into the EU. So first of all, connecting visas with the concept of migrant instrumentalization is problematic because it clashes with the sovereign right of states to regulate the entry and stay of foreign nationals, which also includes through the operation of independent visa policies. Again, if we look at the aim to destabilize the EU, here in this context, in my opinion, it undermines the principle of legal certainty because visas are not generally issued to put pressure on the EU. Visas are legally issued to for very ordinary purposes like tourism, education, employment, or private visits. This is the official purpose. And also, there is significant risk of portraying everyone who receives a Belarusian or Russian visa travels to these countries and then later tries to cross the EU as being instrumentalized. However, from my experience, people exhibit significant agency in determining their pathway, and they have very different circumstances why they try to cross from Russia and Belarus to the EU. Talking about Russian visas, and this is completely different from Belarusian visas. So first of all, we can see the broad range of countries and nationalities who try to cross from Belarus at the moment and over the past 2 or 3 years into the EU. So we can see Syria, Afghanistan, Iraq, Iran, India, Bangladesh, Yemen. Cuba as well, quite a lot of Cubans. So we have heard about the Cuban case previously in an excellent Dario Sartori's presentation. And their reasons and circumstances of entering Russia vary significantly. So first of all, Russia is a big immigration country. It issues over 1 million visas annually, over 1 million, so the latest statistics. They have visa-free regimes with many countries, including authoritarian states such as Cuba. And they have been, like you can see the statistics, it's 15 million entries by foreign nationals annually a year. So we compare it to the numbers of people who try to cross into Belarus. These numbers cannot be really comparable. And also with Russian visas, there's been always omnipresent low-level corruption at Russian consulates abroad. For example, in Syria, after the war in Syria, since 2011, it would be practically impossible for a Syrian national to receive a visa into the EU. However, Russia continued issuing visas for Syrians over this time, and many people use this opportunity by paying people, by bribing people in Russian consulates in Syria, which was possible for them. So Russia also represented for them the way to escape Syria, where other possibilities were closed. And there is also a considerable Syrian community in Russia. Then there are a lot of people who try to get Russian student visas. And there are a lot of universities in Russia who just do business with Russian student visas. So there are very different ways, and we cannot necessarily talk about any state level centralized involvement because there are a lot of different actors on the ground. About the agency of third country nationals involved, and this is a significant issue because generally, if we are talking about migrant instrumentalization in the public discourse, these measures are blanket in nature and affect everyone, so even those who have never obtained any Belarusian or Russian visas. It is implied that all foreign nationals crossing irregularly from Belarus are being instrumentalized. However, we should not forget that many who attempt to enter the EU do not have any Belarusian or Russian visas at all. So there are quite a lot of people who have previously resided in Russia or Belarus long term and try to escape Russia or Belarus due to human rights violations, and particularly in Russia. There are people I have interviewed who arrived to the border by land, and it also includes the period in summer 2021. So, for example, there was a family from Afghanistan who used the very well-established smuggling networks, the Central Asian smuggling networks. And after Taliban came into power, they just fled Afghanistan through the Central Asian route through Russia. They didn't have any connection with the Belarusian or Russian authorities, and they arrived at the border, and they were pushed back and forth like for several months because of the measures introduced by the EU member states in response to perceived migrant instrumentalization. Also, there are people who attempt to settle in Russia, and this is the story of the Cuban case before the European Court of Human Rights at the moment, before the Grand Chamber, where people from Cuba initially attempted to settle in Russia. However, they encountered hostility on the part of the authorities, and they were also afraid of being recruited into the Russian army to fight in the war in Ukraine, which is currently a big problem for migrants and people with precarious residence status, because the Russian authorities are trying to put pressure on them and recruit to fight in the war in Ukraine. And this is the reasons why people try to flee. Sorry, I just lost my presentation somewhere. I don't know what happened.
We can still see your presentation. Your
Can you
screen
see
is
it?
shared.
Because
Yeah,
I can't, yes, now I can see it. I don't know what happened. Sorry. Yeah, sorry about that. Yes, so you can see there are a lot of media articles about people who are trying to escape the Russian authorities via Belarus to the EU, precisely for that reason. So because the Russian authorities were trying to hunt them down and conscript into the Putin's army to fight in the Ukraine. Also, when talking about the facilitation, as it is being defined in the regulation, we should remember that most of the people crossing from Belarus are transported to the border by fixers, smuggling networks, and these networks operate sometimes with no connection with the state authorities whatsoever. So since the Belarusian events in 2021, it has led to proliferation of smuggling networks, which already existed. However, now it has become much more widespread, definitely. And also, like legally, well, if someone wants to demonstrate that the Russian state or the Belarusian state has been directly involved in the operation of smuggling networks, it is extremely difficult task to establish that. Yes, generally, from the perspective of global mobility, so as has been already mentioned before, I think, so the main reason why people would ever try to enter Russia or Belarus and then try to enter the EU is the global passport inequality, of course. And also the instrumentalization narrative, which has been now used by the member states, it effectively allows to exclude the foreign nationals from fundamental rights protection based only on one aspect. So one is only the route they take to reach the EU. And my interviews also revealed that many third country nationals, they have previously unsuccessfully tried to enter the EU via other routes, including the perilous Mediterranean route. For example, here is the quote, and it represents the situation many people find themselves in. So there is a Kurdish person from Mosul, from Iraq, and he was threatened by some groups in Iraq. He wanted to claim asylum in Europe. So he said that in 2018, I tried to go to Europe via Turkey, but Turkish border guards hit me, put me in jail for 10 days, deported me back to Iraq. In 2020, I went to Greece, but Greek commanders caught me near Saloniki, took me in the car and sent me back to Turkey. And Turkey again sent me back to Iraq. And now he tried to go to Latvia. He paid money to get to Minsk, but he was pushed back after having spent 2.5 months in the forest, being pushed back both by Belarusians and Latvian authorities, and returned back to Iraq without his asylum claim even being registered. And he is saying, and this is crucial, now I'm back, but I will keep trying to move to Europe anywhere safe. So it actually shows his agency, which is directly in contrast to the public discourses of people who have been portrayed as passive actors here. So this is the person who actively looking for any possible ways to get to the EU. And then finally, threatening essential state functions requirement, which has been present in the regulation. So if we look at the numbers, and the numbers I think are crucial in this particular case. So in 2021, which was the peak of the crisis, if we only look at Poland, which was the main transiting country for third country nationals involved, there were like 40,000 attempts of so-called illegal border crossings. In other words, pushbacks exercised by the Polish authority. This is the official statistics. The numbers have dropped sharply after 2021. In 2024, we have only seen like 20,000 prevented attempts to cross the border irregularly from Belarus into Poland. And also, which is also important to mention, that many have been pushed back and forth multiple times, and sometimes they have been pushed back and forth for weeks, and in extreme cases for months. So these are only like a few aspects from my field work, which are kind of problematic and in my opinion, do not clearly correspond to the official discourses about instrumentalization, which has always been reproduced. So I'm looking forward to your questions, and thank you so much for your attention.
I hope the mic just can enjoy the applause by the audience. So thank you very much, Alexandra, for bringing to the table some insights from the field and the interviews that really help us understand the context and the reality, in addition to the legal categories, which is clearly important for our purposes, but still to maintain a hold on what's going on in the field. So thank you very much. And so I can give the floor to the last of our speakers right now. So Alexandra, you may want to interrupt. Okay, perfect. Your screen and
Możesz?
use the picture of the Greek hotspot of Moria as a symbol of the emergency situation in the context of migration and asylum in Europe. An emergency-driven approach has surfaced, as we know, from as a mandatory route to reform the common European asylum system following the migratory pressure of 2015-2016. When the European Commission, also based on the agenda on migration, initiated a series of emergency-driven solutions to the crisis. And an example here in point is the relocation decisions adopted in 2015 and establishing essentially the obligation for the member states to accept refugee quotas, relocating applicants from Greece and Italy. The new pact also incorporates this emergency-driven approach, and today we have been talking about the crisis and force majeure regulation. What is important to add and to stress is that this narrative of emergency in the field of migration is very often coupled with a particular emphasis on security. Indeed, it has generated a security mindset that has become a very important element in the implementation of this particular policy. So against this background, what I would like to do, also drawing partly from research that I've been doing, is to address on the one hand the tensions that national measures determine with regard to EU law. And in this connection, I would like to use what I call the weaponization of Article 72 of the TFEU to show how these tensions play a role in that context. And then the second part, very shortly, will focus on whether EU law has an emergency framework fit for purpose in the context of a situation of emergency. So a few considerations also, because something was mentioned in the previous panel. What is a situation of emergency? There is no clear definition, but if we look at recent practice at a national and European level, I think that we can identify some elements. On many occasions, I would say, a situation of emergency in the context of migration has been linked with the mass influx of third country nationals, or in general, the influx of third country nationals. And three criteria, in my view, have emerged in the qualification of this situation of emergency. A first criterion has to do with an element of magnitude based on the scale of the movements of displaced person. And this is often coupled with a parameter of imminence, requiring the expectation of a mass arrival. A second element that adds to the qualification of the notion of emergency can be linked with geographical consideration. So the fact that third country nationals come from a specific particular area, geographical area. And another element that can be also stressed in this regard is the impact that the influx of third country nationals have on the asylum and reception system of the member states. Also because in other terms, this has been stressed by the Court of Justice in relation, for instance, to the systemic deficiencies in Greece, but also the European Court of Human Rights also acknowledged the impact that the arrival en masse of the country nationals can have on the reception system of a member states. And here I'm referring, for instance, to the case of Claifion. So looking now at the tensions that have been generated at a national level with EU law, I selected a few measures that I classified into main categories. On the one hand, we can identify some measures, national measures of practices was implementation has resulted in a blatant violation of important international of EU obligations. And on the other hand, it's also worth mentioning that some national measures took the approach of deliberately contesting EU measures. And just to be short, without paying a lot of attention to the specific measures adopted at the national level, we have indeed legislations from Lithuania or Latvia that declared a state of emergency due to the mass arrival of migrants that led to the suspension de jure of de facto of the right to asylum. Similar story in Poland. I think that in 2025, the president also moved to an official claim to limit the right to asylum. Hungary is also an interesting case when it comes to the transit zones, because since the emergency of 2015, Hungary has been not only undertaking a rule of law backsliding route, but this rule of law backsliding route is also coupled with the progressive dismantling of the international protection system. And an example is the embassy procedure, so the fact that it's virtually impossible to apply for asylum in Hungary if the person does not go to the embassy of the neighboring countries, like, for instance, Serbia. And I think that this morning it was also mentioned that Greece, that in 2020 and also in 2025, basically wanted to limit the right to asylum. So in essence, these measures, so what do they have in common? On the one hand, they make it difficult or even impossible to apply for asylum. On the other hand, they facilitate the forced return. In practice, they are generators of pushbacks. On the other hand, there are also judicial challenges to EU measures, and again here the example is comes from the relocation decision of 2015, and what is interesting to stress is the fact that different arguments have been used at the national level to contest this model, which all in all is a model of solidarity. We can talk about the limits of this model, but it's anyway a first, perhaps of practical example of solidarity. And here the Constitutional Court of Hungary used the issue of national identity to cover the blatant outright refusal of the country to implement this scheme, which has also resulted in an action for annulment from some Visegrad states opposing the idea of accepting quotas. I mention these measures because there is some litigation, and many of these unilateral measures entailed claims of derogations from EU law, which in my view are giving rise to a sort of emergency litigation based on the weaponization of Article 72 that was mentioned in the previous panel. So I will be rather shorter in that regard, but I think it's important to mention very shortly, or to repeat very shortly, what Article 72 has been meant. There are different ways to address Article 72. And I think on the one hand, Article 72 is seen as a safeguard clause. So in the case of indeed public security, public order, internal security, states are supposed to enjoy discretion, and this is a way to safeguard their competence in this field. Another way to look at Article 72 is also a competence limitation. So the fact that, in my view, but not only, this provision especially speaks to the EU institutions that should be well aware when they pass the secondary legislation that this specific provision is to protect the discretion that member states have in the field of internal security. Some commentators also considered this Article 72 as a sort of extension of the identity clause under Article 4 of the TU. And looking at the litigation in which this provision has been invoked, I would like to argue that maybe this can be seen also as a sort of emergency modulator or calibrator, because if we look at the cases related to the field of migration and asylum in which Article 72 was used by the member states to claim derogations from EU law and the reactions from the Court of Justice, I think that we can somehow draw a more nuanced approach from the Court of Justice, also with reference to the notion of emergency itself. And I have here an overview. I will not go into details also for a matter of time, but what is important to mention is that two cases concerning the relocation decisions. The first case, the joint cases Slovakia and Hungary versus the Council, so the action for annulment. The countries basically argued that the relocation decisions disproportionately interfered with their responsibility to maintain law and order, and claimed that the EU competence under Article 78 could not limit their powers under Article 72. Here, the Court of Justice clarified, though, that there is already in the secondary legislation, in that case, the relocation decision, a specific article that mirrors the content of Article 72. And in that case, then, the member states that want to use an argument based on this consideration have to anyway stay within the framework of the secondary legislation. What is even more important to stress is that in case of difficulties, the Court of Justice mentioned in such extreme cases, difficulties due to the mass arrival of migrants have to be resolved in the spirit of cooperation and mutual trust between the authorities of the member states that are beneficiaries of relocation and those of the member states of relocation. So in other words, the member states should try to find practical solutions, but staying within the EU law framework, not avoiding the implementation of this framework. Broader arguments in the second case, the second relocation case, where the Visegrad states, to generalize, basically claimed that they were not violating EU law, because in fact they were covered in their attempt not to implement the legislation based on Article 78 because of Article 72. And here another important consideration from the Court of Justice is that Article 72 cannot be considered as a general derogation clause. To use, if I may, the expression that Professor Daniel Thum used, Article 72 is not a magic formula to derogate from EU law. Then Commission versus Hungary, I would say more nuanced approach from the Court of Justice, because in this case, the Court of Justice did not find well argued by Hungary how and to what extent the arrival, the mass influx of third country nationals applying for asylum could put serious risks and how the use of Article 72 could alleviate the risk. But what is important to stress in relation to this case is that the Court of Justice also emphasized that it's important to make a distinction between irregular migrants and people that apply for asylum. So in that case, what is important to stress is the Court of Justice did not even accept the attempt of Hungary to use a derogation based on Article 72, especially because the third country nationals concerned were third country nationals that were applying for international protection. And finally, we have again the case that was mentioned today concerning Lithuania in the context of hybrid threats, in which the Court of Justice clarified again that the EU legal framework applying to asylum, so basically the asylum procedures directive, already contains a possibility to derogate from the existing framework. And in that case, the member states have to stay within the secondary legislations framework instead of generating evasions from the set legal framework. So to move to the final part of my presentation, what can we infer from this case law is in fact that there is an emerging framework concerning migration emergencies under EU law, and in a chapter that is going to be published in spring, I try to make a typology of emergency response mechanisms that are available under EU migration and asylum law. I'm not going to discuss all this, but essentially I made a distinction between binding and non-binding instruments and identified the three main categories. Some instruments are emergency and ad hoc instruments, but then there are also emergency clauses that are included in different instruments, both in the area of asylum, but also in general in the field of migration. And in my view, also the attempt to the trend towards the externalization of migration controls could be seen as an emergency response mechanisms, because anyway, in my view, these externalization attempts are meant to limit as much as possible the arrival of third-country nationals. Maybe just a few words to conclude my presentation about the crisis and force majeure regulation, because this is going to be applicable as of next year. And we mentioned today that the scenarios in some member states could make possibly these legislative instruments applicable. It's an instrument that would allow derogations from other asylum law instruments, in particular the asylum procedure regulation or the MMR, so the successor of Dublin. So derogations, procedural derogations, but also enhanced forms of solidarity. But there is a procedure that has to be followed, because there is a decision-making behind, as in many other cases of emergency frameworks that we have at the European Union level. So there is the request from the member states, and then an implementing decisions that is proposed by the Commission and the Council. The whole procedure should be considered limited to a time frame of around 1 month, 1 month and a half. So some considerations about the effectiveness of these instruments, if it ever will be applicable. So on the one hand, it requires, I think, a situation of emergency requires a well-timed intervention. This is something that we saw with the Temporary Protection Directive, when in really a couple of days, the member states agreed on triggering the TPD, the Temporary Protection Directive. But we don't know if this is going to happen in a future scenario. So if there are procedural constraints and considerations here, I think that anyway, I don't know if as an instrument, this is an appropriate tool. We have also to consider perhaps the role of diplomatic contacts, because if I don't go wrong, in the context of instrumentalization from Belarus, a way to moderate the crisis was also to invest on diplomatic efforts with the country of origins or transit of their country nationals. But apart from these considerations, the emergency toolbox of the European Union is also quite diversified. And I think that also Professor Casolari before mentioned instruments such as the civil protection mechanism. There is, well, there is the solidarity pool in general. So I think that the member states can have also a preference to perhaps choose another way to address a particular form of emergency in this context. So honestly, I don't know if this is going to be the instruments that in the future is going to play a major role in a situation of emergency. And a very final consideration, so when it comes to the emergency measures of the European Union, some constitutional implications I think are important and worth keeping in mind, because it's true that emergency legislations can inject flexibility in a legal order that has no, as such, an emergency constitutions as the member states. But there are, I think, some considerations that are important mentioning. So first of all, a situation of emergency might tilt the balance of powers, both vertically, so the role that member states and the European Union are supposed to play. But for our discussion today, I think it's important to keep in mind that the EU framework in the context of migratory emergencies has been very much as keeping very much at the outskirts the European Parliament. So in my view, it's a framework where the democratic control is very limited, and this could be problematic. I mentioned indeed the role of emergency legislation as a possible model of lex specialis. It's a way to inject flexibility and to generate a clear system of derogations, but again, this requires attentions to proportionality, but also attentions to the fact that it shouldn't be protracted framework, because otherwise it will create problems with the legal certainty. And finally, an important consideration is the place of fundamental rights, because if we look at the scheme of the crisis and force majeure regulations, but also other frameworks, I think that those measures do not speak to the fundamental rights of migrants. In many cases, these are over-politicized instruments, and there is very little attention to the position of migrants, and in particular, in the case of the crisis and force majeure regulation, there could be risks, for instance, of extensive and or protracted detentions. So on that, also drawing from the title of this conference, are migrants a sword or a shield? I think that a bold message can come perhaps from a judge of the former judge of the European Court of Human Rights. For sure, migrants in such a context shouldn't be considered as cattle that can be rejected at the borders without giving them access to asylum procedures. So I stop here and I thank you for your attention.
Thank you very much, Salvatore, for this intervention and disclosure that brings back to the, I would say, in a tandem with the previous presentation by Alexander. So let's keep in mind what we have in front of us. And I, listening to you, I was quite skeptical about it's a pre-legal in a way reasoning. I'm quite skeptical about this employment of the emergency jargon, the crisis, force majeure, all concepts that evoke situations that are unforeseeable and that are, really special in a way, but it seems like my impression is that those kind of hybrid threats are really becoming part and parcel of everyday discourse. If we switch to the anti-coercion regulation, for instance, right there in the field of economy, it's stated that those kind of threats from some actors, China in the first place, are believed are meant to be happening on a daily basis. So how can we combine these emergency jargons, emergency lexicon with the fact that allegedly those kind of threats are now part of our everyday lives? So I don't know if the response to stick to the title of this panel, the response is adequate to the facts. But these are just some random thoughts. I will now open the floor for questions, both online and in presence. I don't know if any one of you wants to ask some doubts or... Oh, we have one here by Francesco. And I will now look at the chat right now. But it seems like, okay, Francesco, just feel free.
Yeah, thanks. It's just maybe more of a comment, observation on the perception really of emergency. I was listening at Salvo's presentation and the measures that you mentioned, the types of measures, legislative emergency measures. And if I'm not mistaken, you mentioned the temporary protection directive. Which is a legislative tool of 2001, and that has never been used once until a couple of years ago because of the Ukrainian situation. And haven't we had emergencies in over 20 years? There have been attempts to trigger this directive, I believe from Italy, from Malta, but those requests haven't found their way. That wasn't an emergency then, apparently, or so that's. And also, I was thinking of litigation about relocation, the relocation saga that was also mentioned before, and the member states like Poland, Hungary, those countries denying that there was actually a sudden inflow of migrants, so there weren't the requirements to trigger such a mechanism under Article 78, paragraph 3 of TFEU, because, as you said, it was not basically, we're arguing, it was predictable, it was clear, it was a continuous situation. So what I'm thinking of is the different perception of emergency by governments and member states on the one hand, and on the other hand, the meaning of emergency procedurally according to the requirements and that are established under the procedure. So yeah, just I would like to know maybe something from your side on these different ways, perspective of understanding an emergency. You might actually face an emergency, but then procedurally you can't prove that there is an emergency, or you deny that there is an emergency, and that doesn't trigger the mechanism that is there in the law. Yeah.
So anyone else? Two, okay.
Thank you for those two interesting papers, and also for your comments in the end, kind of connecting and coming together. And there's so much overlap between the papers. That's really, really interesting. And I have two short questions, comments. So the first one is there's this whole literature on pricification of migration law, and it says a bit like the two of you said in the end, kind of, is it an emergency at all? Is it a crisis at all if it happens all the time? And I would like to hear how you situate your research to that. Do you think that this is the way that it's going to go with EU law emergency? Is that kind of the strategy that the EU has? Or do you think that there is this whole crisification discussion is not something that resonates with what you do. And then the second thing, when I looked at the judgments that you mentioned, and when you talked about that, one of the things that came into mind was when Daniel spoke and connected kind of the difference of Hungarian politics with regard to their suspensions versus Polish politics, kind of trying to get everyone on board. And that made me think on the suspension issue, because what Poland and Latvia and Lithuania did, it was not really a whole suspension of asylum law. What they did is they suspended it with some exceptions. So only women, pregnant, and children can, and Belarusians, by the way, they can also apply for asylum. So they are the ones that cannot be pushed back. So it's formally citizens of the instrumentalized state cannot be pushed back. They can apply for asylum. So it's interesting to see how their kind of perspective on suspending asylum in this really weird way is actually catching foot in the EU, how they're in this really weird way successful in bringing that in. That was kind of one of the thoughts I had. Thank you.
Thank you, Garzina, and I think that answers the question. There you go.
It's just, I mean, it builds on everything which has been said, and I mean, the way you describe it is the way you have to describe it, because that's the legal framework. Member states rely on these exception clauses, they rely on the exceptional legislation, such as the crisis regulation. But listening to you, I had exactly the same impression as you, and you just voiced it, that emergency sounds like something exceptional, but maybe it's less and less exceptional. They only rely on exceptional clauses. So do you see any prospective way how it could become the new normal? That's, I mean, it's not a question really, but do you see it happening?
I think that we are ready for the replies and your reactions.
Don't know who wants to go first.
I don't know. I don't see any questions from the chat, so maybe we can do it in reverse order. So Salva, a little bit to you, and then to Alexander for some very short and conclusive remarks. There you go.
Yes, so very shortly, I will try to address the questions that have been mentioned, starting from Francesca, your question about the Temporary Protection Directive. This is the oldest measures adopted in the field of asylum, and the reason why it was adopted was a situation of mass influx. Let's avoid the jargon of emergency, but there was a mass influx affecting specific member states, and then there was the need to harmonize the approach to situations like that. I think that a common denominator to all legislative or non-legislative measures in the field is the fact that anyway they are quite politicized, and these has repercussions in their implementation. And the reason why the Temporary Protection Directive was not implemented before the armed conflict in Ukraine, I think it has to do indeed with many reasons, but especially not only, I would say, but especially political reasons, and also for the particular relationship that Ukraine has with the European Union. So the fact that Ukrainian nationals could anyway enter the European Union, and it was a completely different situation for people coming from Tunisia, for instance, during the Arab Spring, or from the civil war in Syria. Of course, there are procedural constraints, because to trigger the Temporary Protection Directive, you need the qualified majority, which is difficult to achieve in a politicized context like this. Yeah, the relocation saga, I think, connects very well with the jargon of using the notion of emergency, perhaps to fabricate the existence of an emergency. And I think that it's true in the sense that the more measures are adopted under the predication that these are emergency measures, the more we actually tend to make the emergency a structural feature of the legal order. And I think that what is important to stress in that regard is that when the new pact was negotiated, now we talk about the crisis and force majeure regulation, which of course is binding. It's a more complex legislative instrument, but this is accompanied by a soft law instrument, which is a blueprint to prevent a situation of emergency. So the question is, what is the potential of all these instruments that are even supposed to monitor the rise of situations that then presuppose the implementation of the hard law framework, such as the crisis and force majeure regulation. Just to give an example, this blueprint relies a lot on the information, quite detailed information that on a regular basis Frontex shares about the number of irregular crossing around the European Union. So to a certain extent, there is a tendency to the falsification of the legal system, perhaps in a way to portray migration as an undesirable situation for the European Union and escape an investment in a more structural and orderly way to deal with the arrival of third-country nationals. I think that was, I don't know if I missed any question. Yeah, Daniel, I think that connects also with your question. So I agree. I think that indeed we talk about emergency framework, but the way the emergency is constructed, it's very politicized way. So could be that all these instruments that are already there, while we don't know what kind of scenarios we face in reality, in fact, are a sort of maybe not new normal, but an ordinary or structural instruments.
I don't know if Alexandra wants to make a brief comment on this emergency and
thank you so much.
normalization.
So thank you so much. So in practical terms, from my own experience, I think that if we are talking about the EU-Belarus border, then the crisification has become already a new normal, and we can see it in practice. So this is the question I asked in the very beginning of my presentation: what needs to happen actually for the member states to stop calling it instrumentalization and emergency on that particular border? And this is the question I would invite you to think about. Is that the re-establishment of border control, so that the Belarusian authorities would need to prevent third country nationals from crossing into the EU? And what happens if they even try to do so but cannot? Because if we look back to the events before the 2021 summer, we can see that there were a lot of people who still tried to cross from Belarus into the EU. So, from my opinion, and actually also if we look at the statements of the member state authority, they do admit many things. They do admit that there are people who have been living in Russia, for example, for a long time before trying to cross into the EU, and that they actually has been not really the involvement of centralized involvement of Russian authorities. So this has been already raised by the member state officials, for example, in Lithuania and in Latvia. However, they still portray it somehow as migrant instrumentalization. Yes, so does it mean that the number of people who would attempt to cross into the EU needs to be zero to stop calling it migrant instrumentalization? I think this is the answer on the member state perspective could be yes. And this is very problematic, of course. And the second point, so sorry, I just, well, the question, yes. So Gracian has asked about the asylum. So generally, it's a little bit more complicated than that, because the legislation introduced by all the 3 member states was it was similar but different. So there are also differences. And like, for example, in Latvia, in the very beginning, and they have been like also legislative changes over the course of the years since the 2021 events. So in the very beginning, like, for example, Latvia has completely suspended the right to seek asylum with no exceptions, including at official border crossing points, which has been an unprecedented measure. And this has been much more restrictive than the measures officially taken by Poland and Lithuania, which still allowed submitting asylum applications officially at border crossing points. So Latvia had been completely suspended the right to seek asylum. It was a blanket measure which had been changed after the decision of the local courts, domestic courts in 2022. And also, just a little more moment, it is very important not to conflate the humanitarian admission you've been talking about, like admission of vulnerable groups, which is again on the discretion of border guards, because I know cases where women, children who have been pushed back the same as men. So there's no ever guarantee that women and children would be admitted. And also, it's called humanitarian admission, at least in Lithuania and Latvia, which has nothing to do with the right to seek asylum. So they are not automatically entitled to the right to submit asylum claim. Yeah, thank you.
You're welcome, Alexander. So that marks the end of panel 3. And now the most, I'll say, challenging task of all day, meaning connecting dots. I mean, there have been some dots put forward and discussed, so thank you, Salvatore. And I cannot but invite Massimo Starita to the podium. Table.
I don't know if I have to thank you for this.
No, I don't think you have. So Massimo, as for the program, he will conclude, offering us some concluding remarks to our discussion. So Massimo, floor is yours. You have 3 hours.
Okay. I will take them all. No. Okay, generally speaking, I do not like very much conclusions. First of all, because this kind of situations happen.
Yeah, but it's gravity.
Okay. Why I do not like conclusions? Because they are, with some very good exceptions, of course. Because generally speaking, scholars abuse of this position to, for example, to make observations concerning specifically the previous one or more of the previous speakers, or this I hate this second possibility that I am going to mention. Sometimes scholars use the conclusions to summarize what was said in the whole conference, or what is worse, they try to authoritatively establish some common shared ideas. I really hate this, so I will not do that. What I'm going to do, I will simply share with you some personal observations that came to my mind thanks to many inputs that I received today from all from scholars who are much more, I would say, who are the specialists and less specialists in international law of migration than many of people who came before me. Let me so start from the title that Diego, Francesco, and Lorenzo gave to our dialogue, Sword or Shield. Before coming here, I found this title intriguing. After the conference, I can add that it was a good choice also for scientific analysis. There are at least 3 reasons for this, and I will shortly develop these reasons as my concluding remarks. The first reason concerns the different meanings that the concept of instrumentalization can have. The second one concerns the different functions that the concept has had so far. And third, the question of changes in law. In my opinion, first of all, the title is a non-technical title, I mean, not limited to law, and this helps making clear that the relationship between law and other dimensions or other disciplines are relevant here. Of course, in our conference, we discussed instrumentalization from the point of view of law, of international law and European Union law. However, I think that we are all conscious that the concept of instrumentalization is something difficult to manage from a strictly legal point of view. In particular, the EU law notion, which is the only binding, legally binding concept today, because it was stated in a regulation, in the regulation on crisis and force majeure, says that instrumentalization concerns situations in which a third country or a hostile non-state actor encourages or facilitates the movement of persons, third country nationals, to the external border of a state with the aim of destabilizing the union or a member state. Now, this notion is narrower than other possible definitions that have been relevant in the field of international relations. For example, if one reads the book written by Professor Greenhill that was mentioned here this morning, the word instrumentalization is used in many different meanings. The reasons for this narrower EU law definition have to be found beyond or behind the law, in the vulnerability of the EU immigration policy to its neighbors' cooperation, but also in the political tensions which characterize international relations today that remind us the Cold War. This narrow definition leaves a lot of things outside. For example, take the decision of a government. I will not say which is the government, it is an hypothetical government, to recognize as refugees white South African rich people as refugees, as a group. This is not in the EU law meaning, but it could be considered as instrumentalization in other social contexts. In other words, what I would like to stress is that as lawyers, we must be conscious that we discuss a European notion that in other parts of the world can be considered not relevant at all or less relevant as we believe. Second point, the alternative between shield and sword, I liked it very much also because it introduces the idea of different social functions that the concept can have. From the point of view of international law, what are the intended functions of introducing this concept? At least three functions have emerged today. They are all connected with the idea of producing changes, law changes, which is my third point. But now, what are these three functions? First of all, it was introduced to justify restrictions and or exceptions or derogations to human rights obligation. These emerged in the litigation before the European Court of Human Rights, which was discussed this morning and even in the afternoon. From this point of view, we also know that member states of the European Union have used this concept also to justify derogations to human rights obligations and EU rules beyond what is actually established under the regulation on crisis and force majeure, as was discussed in the EU law panel. Second, to justify reactions to a third state malicious behavior. The concept was also introduced to allow reactions to a third state instrumentalization. That could even amount to countermeasures, that is, violations of international legal obligations, as was discussed in particular in the first session by Francesca Tammone, but which also came sometimes during the whole conference. Finally, there is also a third important function that the concept has had and probably could have in the future. In particular, I mean that it is also being used by the European Union in its more general effort to present itself as a strong, full subject of international relations, which is entitled, in particular, to react to third states' behavior. In other words, the European Union is claiming that the principle of non-intervention, which was tailored on sovereign states, has an enlarged scope of application, protecting also international organizations in general, or at least the European Union. So, as I told you before, these three functions all concern changes in law. Instrumentalization was introduced to justify activities whose legitimacy needs changes in the existing rules of international law. I'm not saying that these interests, these exigencies are not morally speaking or politically speaking right. I'm just saying that from the point of view of international law, changes are needed. But we must acknowledge that the mere fact that the EU introduces in its own law a concept is not sufficient to realize these three aims. Changing international law can be produced only if two criteria are met. First of all, other subjects have to accept them. Second, they need time. First, other subjects must be involved. These subjects are different depending on the field of international law concerned. As far as international law beyond human rights is concerned, what is needed is a general practice of third states and their opinio juris. And from this point of view, I do not have difficulties in admitting that instrumentalizations can be contrary to the principle of non-intervention, as Francesca was saying in the introducing session. However, we all know that the principle of non-intervention is probably one of the most debated, complicated rules of international law. And many of the questions that are open in generally for non-interventions apply also here. Just to give an example, what are the activities material activities that can be under the concept of encouragement and facilitation? As it was clearly stated this morning, there are some of these activities which are lawful, okay? This is the first problem. The second problem concerns the subjective element, the intent. Well, now it is true that in the Belarus case, this intent is easy to find. It can be clearly found in some Mr. Lukashenko's statements, but generally speaking, proving a malicious aim is one of the most difficult things to do in international law. Even if we come to the question of the expansion of the principle of non-intervention to encompass European Union or international organizations in general, here too, the will of the third states and or other international organizations becomes important. In other words, what I'm trying to say is that we have always to think that this concept is a European Union law concept that needs to be matched with something which is beyond European Union. Europe now, human rights obligations. Here, instrumentalization is, let me tell you, let me just remind myself that it is probably the most recent in a long list of concepts that have been introduced to allow exceptions, derogations, and so on of the human rights of migrants. These concepts have often addressed changes through interpretation as claims of restrictive interpretations. Theoretically, I have no problems with the idea of changing the international law of human rights through restrictive